Okay, ladies and gentlemen and ladies and gents, got a little bit of something we want to talk to you all about. And we're going to take just a little bit of time. As you notice, we've been doing some short videos, not been doing anything really extensive because we're not doing research for you, not trying to research anything for you. That's not our job here. Who we going to be bringing on right now? That's at 27. I don't want to be as high as 27. Right about 22 should do. Okay. Alexander O'Neal and Sherelle. Oh, y'all know I got to play me some Alexander and Sherelle. My only problem is I can't hear them. There you go. Woo! Never knew love like this, y'all. Alexander O'Neal and Sherelle. Ladies and gentlemen, yesterday I did a video, simple video, telling you guys about something that actually worked. And we talked about the young lady going in and just signing the mortgage and the deed of trust. We told you guys that the loan has already been completed up until that point. Okay? Well, the court agreed, not saying those exact words, but when it said that the bank had no standing in the court case, the court agreed. That was what the intent was when they were going to go in court and argue. And you said argue again. Anyway, when they were going to go into court and bring forth their portion of their side, they were going to be bringing up the point that this was a loan. The bank has nothing to do with this home. I received a loan. I used the money for the loan to buy a home. The bank has nothing to do with my home. They don't have a power of attorney. I've not given them any authority over me or my home. The court agreed. As we told you, the loan has nothing to do with the home. The mortgage has nothing to do with the home. The mortgage only allows the home to be used as collateral. For what? Not for the loan, because you've already received the loan. You don't need collateral. When you're signing that mortgage, you are allowing it to be traded on the market. Now the home is collateral because trading on the market is a risk, as everybody knows. So it's not guaranteed that you're going to make a profit. So you use your home as collateral. Okay? That's the system. That's the way it's designed. We're going to play this, and I'm going to tell y'all while I'm playing this, and I'm going to tell you what my disgust was. And yeah, I could say the word disgust because I wasted some time this morning when it should have been contributed to something productive and beneficial. I don't like learning nothing. I'll explain it in a minute.
Ultra-virus banks. Bigger text plus smaller text. Ultra-virus banks. The United States Code, Title 12, Section 24, Paragraph 7 confers upon a bank the power to lend its money, not its credit. In First National Bank of Tallapoosa vs. Monroe, 135 GA 614, 69 SE. 11/23/1911, the court, after citing the statute heretofore said, the provisions referred to do not give power to a national bank to guarantee the payment of the obligations of others solely for their benefit, nor is there any authority to issue them through such power incidental of the business of banking. A bank can lend its money, not its credit. Meanwhile, they do it anyway from a profit motive, even though it flies in the face of their primary duty to protect people's money. In Howard and Foster Co. vs. Citizens National Bank of Union, 133 SC. 202, 130 SE 758, 1927, it was stated, it has been settled beyond controversy that a national bank, under federal law, being limited in its power and capacity, cannot lend its credit by guaranteeing the debt of another. All such contracts being entered into by its officers are ultra vires and not binding upon the corporation. An activity constitutes an incidental power if it is closely related to an express power and is useful in carrying out the business of banking. See First Nat. Bank of Eastern Arkansas v. Taylor, 907 F2D 775. But even with this latitude, no hint of lending credit is provided in 12 U.S.C. 24 that would give rise to an incidental power to lend credit. The exercise of powers not expressly granted to national banks is prohibited.
Okay, ladies and gentlemen, I can only share that part with you because it is necessary for you to understand something. The only thing that banks can lend is credit. In other words, all of their loans are credit loans since 1933. Why? Because there is no money. Pay attention. Not that one. That's a different one. I got to find it. Give me a second. It's going to be here, 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 here. Doesn't that sound like the birds in the morning of spring? Here, here. Anyway, it's going to be here, ladies and gentlemen. And I want you to understand, since 1933, there has been nothing that would even come close to being lawful money. Why? Because even the Treasury says that legal tender notes, such as those so-called Federal Reserve notes, have no value. They're not money. Now you have to look up the legal definition of money. The banks can't lend their credit, so what are they lending? And remember, by challenging the Act of March 9, 1933, but you run into two problems. You run into two problems if you bring that argument. Remember, the biggest argument is not whether or not they loaned you money. Okay? Because the money will be back. It will be worth 100 cents on a dollar because it is backed by the credit of the nation. The nation can't lend credit either. There's nothing in the law that allows the nation to lend its credit to anyone. The Constitution doesn't permit that. The United States has full faith and credit, but it doesn't get to lend its credit. But when it issues this money, it's lending credit. Now, you can go all over the world with that stuff, but the issue is you don't want to bring up that they lent me credit, they didn't lend me money. You don't want to bring that up. You want to bring up the fact they did lend me money. And I returned it in the same species. I paid it in full. And I just need to see the accounting because I don't agree with the amount they're claiming is owed. It's not whether or not I can prove how much I paid. It's I need to see the actual accounting to make sure what they're claiming is the actual amount that's due. That's all I'm asking, Your Honor. And I have the right to see the actual accounting because it's my right. It's about the Truth in Lending Act. And I know you understand what I'm talking about because you're not that stupid, Your Honor. I mean, you're stupid, but you're not that stupid. I mean, come on now. Okay. So let's tell you in a nutshell. Uh-oh, he turned Never Knew Love Like This off. He's going to turn it back on, y'all. All right. Ladies and gentlemen, let's... Oh, that's a pretty skyline. Oh, it looks like it may have been doctored a little bit. See, the color is not actually true, but it's color. Oh, look at that. That is, oh, what's that tower? That looks like it might be in Numberski. Yeah, that's where that looks like that might be. Hold on, ladies and gentlemen. Let's show you, as I spoke at the beginning of this conversation, how this is what the person sent me in an email. I asked everybody for how to rescind a deed of trust. I just need case law on rescinding a deed of trust, rescinding a promissory note, you know, the so-called power of attorney, respecting a deed of trust, power of attorney, respecting a promissory note. How to rescind that. I don't need theories. I need case law that specifically refers to that. So this person said rescinding an assignment. That's what I asked for. How to rescind an assignment. Well, guess what, everybody? The person sent me this case law. So I took the time to go and look up this case law. Talked about omissions and talked about blank endorsements. It even talked about Wells Fargo failing to do an assignment. So they pulled up a case that was dismissed that mentioned assignment, but they didn't even look at the case. They just sent it to me. No, that ain't working, people. I'm not here to do the research for you. Sorry, I don't have the time. This case right here doesn't talk about no rescinding of assignment. Oh, and God, this case only talks about the ultra-virus issue, doesn't talk about no assignment issue. Oh, by the way, remember the banks can't lend their credit, so what about these credit card companies? Aren't they lending their credit? Oh, remember, every credit card company must be a bank now. Okay, none of this other stuff talks about the rescission. Qualified written request definitely doesn't talk about your ability to cancel the power of attorney. This doesn't help. Vision of love. I had a vision last night, y'all. Okay, it doesn't help. Am I frustrated? No. Am I angry? No. I'm just unhappy because it was very misleading for them to label the caption of the email rescission of assignment. None of the cases talked about that. None of the information talks about the rescission of assignment. And I already know what a notary presentment is. Matter of fact, I just advised somebody to do a notary presentment yesterday. This is not new information. None of this is new information to me. That's what I was trying. That's why you guys heard me say in a video about the legally wise individuals, about them doing the research, because this is not for the people who just started researching, who have no history of understanding legal terminology, because it's not helpful. Again, this is not about who knows more, when, how, or why. This is about the fact that I'm not watching your videos, so you're not bringing me new information. What do I mean by that? I mean, if I was looking for something and I stumbled onto your video talking about something and you were bringing some new information, then I'd be watching your video. But no, you're watching mine because you're here to get information that you don't already have. So how is it possible that you can assume and then provide me information that you think I don't already have when it's about the very nature of the things that I've been talking about? But I'm giving you a lot more detail. I'm giving you the foundation of it. In a nutshell, I don't care if this, and you got to really understand, I feel for you. Shaka Khan. I feel for you. Okay? I feel for you, Shaka Khan. I have to always say Shaka Khan after I say I feel for you. I got to give her credit. Okay? Well, technically, I got to give Prince his credit because he wrote the song. Okay? Ladies and gentlemen, I feel for you. But I need you to understand, I don't care if you take this negatively, positively, up, down, sideways. It doesn't matter. I don't have the time to be going over nothing, something of no value. I decided to look this up because blah, blah, blah. I thought it might be helpful. And if it would have been helpful, I would have shared it with you. You know, a lot of people told me, well, no, I just don't want you sharing this with the public right now. What? What do you mean you don't want me sharing it with the public right now? What are you talking about? You don't want me sharing it with the public. Is it private information? Did you look it up on a private source? Is it held up under lock and key? Ladies and gentlemen, I don't share all the information I have. But if it's general information, if it's something I'm not in a contract, and if I think it'll be beneficial, I'll share. Hey, don't. This is like candy. I can feel it when you walk, even when you talk. It takes over me. Cameo. Ladies and gentlemen, if it's beneficial information and it will benefit you and benefit others, I don't have a problem giving that to you. I do have agreements I made with several people where I can't give you the information. Why? Well, because they are working out something, and what they're trying to work out, they're using a different spin, a different angle. Okay? Just that simple. So, certain information I can't give to you. All right, once again, the banks can't lend their credit. If the banks can't lend their credit, then the issue is the accounting people. You have to go after the accounting because, as was determined in the case yesterday, the bank had already gotten paid. Why? Because they had already issued a check to the previous owner of the property. Oh, I didn't tell you? No. The individuals went to the owner and got a affidavit from him saying that he had already been paid. Ladies and gentlemen, she didn't sign the promissory note. All she signed was the mortgage and the warranty deed. That was all. She filed the warranty deed. So if the bank comes and says, you owe us, I need to see the books because that money came from my account. Okay? And even so, now you got to take me to court. You can never foreclose on the home because you don't have any rights to the home. I used the money to buy the home. The only thing you have is you can bring a claim against me telling me I need to pay you back. That's fine. I'll pay you back, all right. Here, there's your tender. Our style, it's a money order. You take that and do the same thing you did the first time, but I believe your records are going to indicate that you already got paid. That's what that whole funding thing is about, ladies and gentlemen. Well, we're just waiting for funding. Pay attention. We're just waiting for funding. Where's the funding coming from? United States government, because all mortgages are backed by the full faith and credit of the United States government. We just read that. Okay, that was her situation. Guess what, ladies and gentlemen? I brought that to your attention because I didn't want to give you information you already knew. I wanted to let you know what was going on. Conversation that I was having with the people, they went off of information they got from me and from my videos. And when I heard how things were going, I decided to lend them an extra hand. Oh, and I got people, we have one situation where somebody contacted SATCOM and ordered one of the SAT packs, and there's an email that's automatically generated. That email tells people, hey, this is what you need to do. And the only thing you need to do is fill this thing out, get it notarized, send it back to us with this item. And by the way, here are the other steps you will need to follow while we're waiting to get that back. The individual emailed twice saying they hadn't received anything in the mail. So we responded back. There's an automatic email generated with all the instructions and informations and the documents. The person never said anything. They went and requested a refund. So they received their refund back. Ladies and gentlemen, I just simply asked the person, where is it that we promised to send you anything in the mail now? We sent you something in an email because that's the way the process works. But there was no promise. Where is there a promise that we're going to send you something in the mail tomorrow? If we sent it to you in your regular mail, it's going to be the same thing we send you in an email. So where did we promise to send you something in the mail? You're waiting for something in the mail, but we don't even have your physical address. So how can we send you something in the mail? Sorry, ladies and gentlemen, I apologize. I knew that there was a misunderstanding. And the reason why I knew there was a misunderstanding is because the person was asking for something in the mail. Ladies and gentlemen, I used to be able to read minds, but my God told me to stop. Oh, that's a pretty picture. It looks like it's God talking to you from above. My God told me to stop reading minds, and so I can't read minds anymore. So how are we supposed to mail something to someone? What were we supposed to mail to this person? And where were we supposed to mail it if we don't have a physical address? All we had from the person, pay attention, is they ordered something from PayPal. No address is given to us. The order with PayPal is through PayPal. It's not through us. In other words, when you type in an information and you pay with your credit card, we don't get your credit card information. It's not information that's shared with us. And that's the way you want it to be. You don't want them to share your credit card information with every company you order stuff from. You don't want your information being out there and shared with everybody else. So, ladies and gentlemen, there are some misunderstandings, and I don't know how that could be. I really don't, because I'm very specific. When I told people I'm just looking for rescissions of deeds of trust, rescissions of assignments, rescissions of the power of attorney respecting a mortgage. That's all we're looking for. We're not looking for cases where they were dismissed because of this or that. You people, if you find a foreclosure, most foreclosure cases are dismissed because of a technicality on the part of the bank. They didn't do this, they didn't do that. What you don't know is now the bank gets to go back and do this and do that. Do you understand? Now they get to go back and correct this and that. That doesn't help, because all the bank has to do is cure the error. We don't want the banks curing no error. We want the banks being held liable. We want to bring up the fact that they've already been paid, but the courts are not letting us bring up these facts. So the only thing we can do is put them in a conundrum. Did you say conundrum? I said conundrum. What does conundrum mean? Well, to get technical, it's none of your business. Don't nitpick and hold on to certain words I use. Deal with the context I'm sorry. He keeps interfering, and I apologize for that. Ladies and gentlemen, we're here to put the bank in a bind. We want to see their financial records, because the financial records will show they got paid in the inception of the loan, of the so-called loan, as is the case that happened this week. She went to sign the loan docs on Tuesday. She went into the house on Tuesday. The bank had her arrested for no reason. The judge ordered full restitution to her for that arrest. Okay? Because the bank had no authority to arrest her. They had no authority over the house. They had no power of attorney. The bank could not have the police arrest her for the property because the bank had no control over the property. They had no assignment to the property. The bank had no power of attorney over the property. The property had nothing to do with the loan. The court agreed. Exactly what I've been trying to tell all of you. Then the court told the bank that it was throwing out its case because it had no standing. Did it use the word standing? No. But its decision focuses on one thing. They dismissed the case because the court said that he did not have the proper paperwork to proceed. He did this without having any information from the young lady or her attorney. They never got to speak. The only person who got to speak were the lawyers for the bank. Here's the problem. I told them the bank is going to come after you. Why? Because this is a game changer. Why? Because you just proved how the system was supposed to work in the first place. When you signed that note, they took it to the treasury, they got paid. Okay? The house is supposed to be yours. That's the process, people. You're not supposed to be filling out all that other paperwork. Can you in the future do the same thing if you're buying a home? Yes. All you have to do, remember, you have an opportunity to read the paperwork. So what they're going to do is they're going to try not to include certain paperwork, not give it to you until the end. Can't do that, because then you can bring that up later, saying, oh no, they didn't give me that until, well after. They made me sign over my power. Those of you who just recently signed mortgages, you have 3 years to rescind the contract. Well, actually 72 hours is the original, but to rescind a mortgage contract, you have 3 years. Just do the research on it. Okay? Wait a minute, you just told us we have 3 years to rescind the contract. So you already know how to rescind the contract. No, I need to know how to do it after 3 years, people. Okay. Oh, wait. Oh, snap. Did I just explain to you guys I already know? That's why I'm asking for the case law. Ladies and gentlemen, I already know what I'm talking about. I just need the case law, and I don't have time to do the research. Why? Because I'm spending too much time researching junk that I don't need to be researching, because people are sending me junk that I never asked for. Mislabeling the title of the email. Okay? So, now that you know that the loan that you receive from the bank and the mortgage have nothing to do with each other, pay attention. Remember, they say the note must follow the mortgage. The mortgage must follow the note. Ladies and gentlemen, pay attention. Neither one of them have anything to do with your home. You received the loan without posting any other collateral but your credit. That's how you got the loan, as your credit. Yes, you had to pay a higher down payment because of your credit, but you received the loan because of your credit without any other collateral. So the home is not collateral for the loan, because you cannot collateralize that which you do not have any power of attorney. Did the court not say that yesterday? This is what I've been telling y'all. Get out of here. Nobody wants to hear about no verdicts. Ladies and gentlemen, pay attention. The court just made sure everybody knew that the bank had not collateralized that item, that the home was not collateral for the loan. This is what I've been trying to tell you. That's what the case revealed yesterday. The home is not collateral for the loan. The home only becomes collateral when they want to trade it on the market. That's why they need that mortgage, so they can mortgage back the security. What's the security? It's the mortgage. It's that promise. Another promise, not the first promise, but the second promise, because the original promise to pay was the paperwork you signed to get the loan. You're just going to have to mail over it, people, so that you all can start getting it. I would go back over this video and get rid of the ranting about the people sending me information that they didn't need, and focus on the issue that the bank doesn't have anything to do with the home. The loan doesn't have anything to do with the loan, or the home. The home has nothing to do with the loan. You allow them to trade your property in the market. That's why the mortgage was introduced, because it was a mortgage-backed security. Do the research. Understand how mortgage-backed securities came about, how all that trading stuff came about. They didn't originally trade these homes that people borrowed and all that stuff. That came about later. Ladies and gentlemen, they created securitization. Remember, securitization is their word. Mortgage-backed securities, that's their game. Why? Because they were creating a market, an economy. All right, ladies and gentlemen, gentlemen and ladies, ladies and gents, have a good day, have a good night, have a good life, have a goodbye.